about the actual legislative cases, I'm so the first in 1993 there was the Doctrine de la Découverte, so the discovery doctrine. So yeah, what I'm saying, of course, it was unjust and unfair and racist, but it's also been repudiated by the Pope. So I was wondering, because of that, if that was enough to invalidate non-indigenous laws. So I don't have enough experience, but in my understanding, since Marshall has used kind of that thought, since he in the U.S., since he based it on the doctrine of discovery, for me it means like that the basis of our laws is kind of unrooted, but I'm not sure. So in 1613, there was the wampum, two-row wampum, so it means that the nations were supposed to be able to each be besides, with their laws and governments. In 1701, there's the Grande Paix de Montréal. So this, what is important to remember in that decision is that all indigenous nations and the French, I think, decided to share the hunting territory, like the territories for hunting, and so this is the treaty is still valid. So it means that the all indigenous nations already have a kind of common ground to settle their claims and to help their negotiations between them, so that they don't fight each other. So, and there's also the liberty of business that's entrenched in it. So it means, that it's still valid. Then in the 1763 Proclamation Royale recognized that indigenous people have lands, own lands. So I'm not sure here if it's just west of Canada or everywhere. And also that l'honneur de la couronne, so the honor of the crown, so there's good faith that is mandatory in negotiation. And also just, just the crown was able to buy her land in that. So, but what is important to remember is, the honor of the crown. So I've put also this in 1774. There's the Quebec Act. There's they took away the French laws, and here they put it back for civil causes. So it means that two laws, two set of laws coexisted here in Quebec. So if two, then means three, and So so the rest is not so important. And what is implicit in the Royal Proclamation is that the indigenous people had rights of self-governance on their lands that belong to them. So in 1867, yes, not very good. And then what is missing is that there was no indigenous government recognized, neither. So bad treaty. So 1975. Traité de la Baie James is the first modern treaty that became a prototype, and it's constitutionally protected. And it came because there was a fight, like the decree went in court against the Quebec government, and but at least it's a bit more fair, but not perfect. So 1982, the Canadian Constitution recognized rights of governance rights to Indigenous people. I'm not sure about the fact that Quebec has not signed the constitution. If it changed anything, I think it still applies to us, but I'm not sure. So yeah, so I'm saying it's still unfair. And then, but I'm talking about what, yeah, again, my slide insists on what is still useful. So the recognition of rights and laws, the recognition to the self-governments, yeah, and the UNDRIP, the honor of the crown, you have to be of good faith when you negotiate, and then the mandatory consultation of PIC. Then also I'm talking about law cases. So in 1973, Calder decision. So it recognized that indigenous people had titles before colonization, so it's not extinguished their rights, and also they had the traditional oral stories are admissible as proof. And then in 1973 too, there's the not important. The 1990 is the Sparrow thing, and that would be there was a test, and that test would be changed by the Montour ruling. And then in 1997 there was the Delgamuc that so that it's the indigenous it's really rights of property, like they own the land. That's what I understand. And also they have the obligation to consult on indigenous traditional territory. And then also that the province cannot extinguish rights and titles. So, and would be the same in Quebec here. And the oral stories are equal in as written testimony. So, though at that time there was still the obligation to prove sufficient territorial occupancy, continuous and exclusive, but this with UNDRIP will be, undone. So in 2008, there's there's the tribunal that has been put by federal government to solve specific claims on lands issues. But what I understand is that now it's better to avoid that tribunal because it tends to be favorable to whites, to settlers, and not, especially now that UNDRIP is there, it's better to really be, positioned on UNDRIP. And then in 2014, it says that basically provinces are obliged to make settlements with the nations and consult nations. And no coupable, like no clear cut of woods was allowed also. Okay, and then I'm talking about the grassy narrows. They lost in grassy narrows, but what I understand is that was before UNDRIP and FIC, and they would probably win today, but maybe they want to wait to go back to court until there's more cases that are there. I don't know. So in Daniels, in 2016, what it means is that Indians in the cities are Indians, and so that they have the right to be consulted and on their needs, and and so in 2016, there was in Tiatlamins in BC, like they obtained crown earth lands and the right to manage the resources, both of their reserve and their the crown land that they got back, land back. So this is very interesting. So what I understand is that it's easier on territory that have not been ceded, like BC and Quebec. So because there's no treaty, so it's easier to do the land claims for now. And if eventually, probably, yeah, we could renegotiate. So, and also that the jurisdiction, the case laws of both BC and Quebec apply to each other, or can be used by lawyers, to prove their case. So